Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Trying to recover myself just a little bit. Good morning. See everybody taking a seat. Thank you. Come on in. We have such an exciting day today. Before we do anything, let me turn the music down just a little bit because my head hurts so badly. All right. Before we do anything, I have to welcome Julie. Julie McBride. I believe, Julie, this is the first offense for you. You were first in chat today. Congratulations. That is wonderful. As punishment for being first in chat, we're going to send it to you with internet ownership, and you're responsible for maintaining everything IP-related or connected to the internet worldwide. It's a small thing, but I'm sure you can do it. Congratulations. Thank you very much for being first in chat. We couldn't start without you, and now here we are. Thank you very much, Julie. Also, Kim the Justice Junkie kicked off the morning gifting 20 memberships. Kim, thank you. That is awesome. I did not see where they all went because I was not ready and it had already scrolled. But thank you. There are 20 people who are very appreciative for your generosity this morning. Thank you so much, as am I. Also, juror number 1, MK versus J Hatch. Welcome to the gallery. Good to have you here. Thank you. We'll be in touch, I'm sure. Mustang James, welcome to the gallery as well. Thank you very much. Good to have you here. Let me tell you a little bit about what's going to happen today. First of all, my head is splitting, but the drugs are kicking in, so it's going to be fine. It's going to be all right. The 3 hours of sleep I got last night were spaced out over a long period of time. I could not sleep because last night, first of all, I talked again with Jennifer Anderson, the wife and business partner of Greg Anderson, who was the lead attorney in the Maya case for the plaintiff, and talked with her. She put me in touch with Kelly, her paralegal, and she sent me a whole bunch of stuff that we can use on the live stream today. And so she sent me pictures, of the Kowalski family. We've got audio, never before heard audio from. Recorded phone calls, things like that. We've got some audio that we put in there. I can't play all of it. They provided a lot more than they provided a lot more than I can use on this. But I went through all of it last night. I put together actually a small video that combines most of what they provided for us, and we're going to watch that during the interview at noon. That starts at noon, and it's all put together to a song written and sung by Maya that she wrote while she was in the hospital. This is I think you're going to love it. I think it's incredible, and I'm so grateful that Jack, the family, and the legal team were able to provide this for us, because it really it gives us a little peek behind the picture, behind the the front, behind the curtain, so to speak, into what was going on. And we'll have so much more of that during the interview. I think if everything works out properly, we're going to have Jennifer Anderson as well as Kelly and Katie, the two paralegals, on with us during lunch, and they know everything. These three women are what made this happen behind the scenes, as far as every document, having read every document, knowing what everything that's going on everywhere. I'm so excited for this. Anyway, so if it's going to be live as well, so if you have questions for them, please bring those, and that's going to start at noon. It's going to be a new. Actually, I'm just going to make it live right now. I'm not live, but I'm going to post the. Okay, there we go. All right, I just made the placeholder public for that, so that's going to start at noon. It's going to be a new video. We're going to stop this one and start the other one. Anyway, that is coming up, and we're super excited. I'm jazzed. Will we need tissues? Yes, Megan. Yes. Need to be prepared. You might need some tissues. Let's see. I don't do my best video editing at 3 o'clock in the morning, but this one turned out all right. Yes, also sisters. Yes, it's you're going to hear this is a family thing. This law firm is very much family oriented and built around a family. So we'll get into that here this afternoon. So please mark your calendars, save the space, and see if you can join us for that. Let's see. The ladies are the backbone of the operation. They are. I'm so excited. I mean, I was talking to Jennifer last night, and we were walking through making sure all the equipment was working and audio and everything, because I don't want to mess this up. And I'll save it for this afternoon. Anyway, it's really cool. I'm so excited. I'm so grateful that they're willing to come on here. All right. Let's see. Kim R says, "Woohoo! I'm the first on the upcoming one." Well, Kim, you're going to have to keep the internet running smoothly, and I'm a little bit worried because I'm going to have to switch some things around to get the audio to play right while I'm live, and then switch it back so that I can hear everybody and they can hear me. So I'm hoping it doesn't cause big problem. I've tested it about 1 million times, and I'm just sure I'm going to make a mess of it during the show, but we'll try. All right. Do we have any birthdays this morning? Any birthdays? It's going to be noon. It's 8:30 right now, so it would be, or 8:40. It's going to be noon time. So that's 3 hours and 22 minutes roughly. But do please invite your friends, share it out if you want to, if you have access to a page where people might be interested. Let them know that's coming up. The placeholder's out there, so you can let them know. I think this will be an amazing look sort of behind the curtains there. All right. Let's see. I know there was a birthday here. Brown Barn, right now I'm just trying a lot of ibuprofen. So let's see. Do we have any birthdays? Hey, this is interesting. Donna Alders, I've not followed this trial. This has been more, I think Brandy's been following that a little bit more. But some interesting developments in the world of true crime. True Crime Junkie, welcome to the gallery. Look at that. Yellow Courthouse by your name. Thank you. Thank you very much. And Margaret R., also 6 months. Always looking forward to being here every morning. You are. Thank you, Margaret. I appreciate that. It wouldn't be the same without you. Thank you. Let's see. Good morning to all. Happy birthday, Jules. We need Jules. Jules' birthday. Anybody else? Anybody else we have to sing? Let's see. Brianne, I did watch that police chase. It is hilarious. I mean, not hilarious, but they got so many interviews with people after the fact. I've never seen anything like that. There's so many police cars. I thought that was funny, having worked in the news before. All right. Let's see. 8th anniversary, Aunt Toots. That's awesome. Congratulations. Have some caffeine. I have 0 caffeine in the house, and I have no cars. All the cars are gone. My family has gone every which direction and taken all the cars. So I have to walk down to the store if I want to get anything. Sharon wrote a whole essay of birthdays for you. Okay, let me look. Where is it at? I know we had, I think Katie or Kathy, one of the two today. Let's see. Anybody else? Sharon sent birthday wishes for today. Where did you send them to? I'm looking. There it is. Okay. Whoa. All right. So we have Jules, Kim, Jackson, Kathy, Christopher. Oh, wait. Christopher Orth's mom, Kathy. So 2 Kathys. Wiggles. Bug Duggers. Hubby Brent. Oh, man. Okay. I've got to write this down. My head has... It will mess this up. Okay, so we've got Jules. Kim the Justice Junkie. Jackson. Kathy. Wiggles. We've got 2 Kathys. Can I just say Kathy one time? Is that all right if I sing to both of you at the same time? Wiggles, Brian. Okay, there we go. I think we've got, this is like a 2-verser. We can do 3 on 1. Jules, Kim, Jackson, Kathy, Wiggles, Brian. Does that work? I'm hearing a resounding yes from everybody. And Gabby. Happy birthday, Gabby. Okay. So Gabby, we're going to add Gabby on the end there. Gabby. Gotcha. All right. It's Kathy's birthday. I just want to make sure I've got everybody on here. Just stutter the Kathy. Kathy. Okay. Kathy times 2. There we go. All right, let's do this. Everybody, best voices, because I'm a little bit under the weather, so you need to pick up the slack. La 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 la. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Jules, Kim, and Jackson. Happy birthday to you. Okay, so the next verse we've got Kathy twice. Kathy, Wiggles, Brian, and Gabby. Here we go. One more time. A little louder in the back, guys. I can't quite hear you. Happy birthday to you. Happy birthday to you. Happy birthday, Kathy, Wiggles, Brian, and Gabby. Happy birthday to you. That was beautiful. I could hear you guys. I know I see it in chat. I think I actually hear it outside. So neighbors must be singing along. Happy birthday to everybody who has who has a birthday today. And for celebrating, we're charging Danilo Cavalcante with 20 counts from the manhunt. Wow. Happy birthday, guys. That's what you get. Anyway, thank you very much to everybody who has a birthday, and hope that we can make your day just a little bit better today. Thank you for celebrating here with us. That's wonderful. All right, greetings. Happy birthday to y'all. Thank you, juror number 1. Thank you very much. Let's see. Mayla's mom says, holy cow, where have the 6 months gone? This community really makes my workday better. Thanks for everything you do, RA, and mods. I would say mods more than RA, because they do more than I do. They're incredible. All right. My husband was even singing with you today. Holly Mack, that is awesome. We've converted him. He's on board now. How much do we need to donate to get the lyrics and names with timing and a sing-along visual on stream? Mathis, wow. Do you need like the little bouncing dot over the happy birthday? I mean, how in depth does this need to be? All right. Let's see. It's my birthday as I'm Irish. Ray, happy birthday. Happy birthday. See, I just have to know, how can I make my own channel content while watching Recovery Addict? What kind of content do you make? I see mixed media madness, Michelle. What is your genre? And is it on YouTube or somewhere else? I'd love to take a look. What's the next trial going to be? Rudy, I don't have it yet. We're trying to find the timing. I like the ballerina trial. Isn't that coming up here very soon in Florida? I've got to go back and check my notes. My head's too foggy to answer off the top of my head. Call-in karaoke style is my suggestion. The problem is the slight delay on the burner phone. The burner phone is not quite as prompt as we'd like. Red Pen says, 10 months. I'm honored to be part of this channel. All right, thanks for all the hours I've spent with you all. Red Pen, thank you very much. Those have been wonderful hours. Appreciate you. Ella Cole says, juror number 1, the humor in your allegedly questions was not wasted. We loved them. We loved them. Goodness, I remember when I found you for a trial, and I haven't left. Never will. I'm captivating. Thank you very much. Wonderful to have you here. Thank you. Here's what we have. We have court hopping today because we've got this interview this afternoon. After that, we have one more interview I'm lining up, and that's going to be with Dr. Corcoran. He's appeared on a couple people tonight. He's going to be with Law and Lumber. Rob's going to have him on tonight. So I've actually got a link already built for our afternoon live stream, even though it's not going to be till later in the evening, just so you can jump over there, click the like button, and click the notify button when that's all done. So we've built all the links to get you there already. Let's see. Let's see. I think we're good on that. Okay. Let me pull up. We may also go back and watch a trial that's already started that we have not kept up with and catch up to, but I'm not sure yet. We're just still looking for those. Today I wanted to see. Let's see, it's 8:48. Where's my? Let's see. Donald King says, did you see that Donna Adelson was arrested by the FBI trying to skip the country to go to Italy? It did come across my feed. I did see that. That is quite interesting. They were not done with those guys yet. The day RA challenged us to go out on our porches to sing Happy Birthday with our neighbors, I had to look out the window just to see if any neighbors were singing on their porch. I'm sure they were, C. Taylor. I'm sure they were. Attorney Melanie Little's doing an interview today, too. Is that also with Dr. Corcoran? Did see Dr. C on Megan Fox yesterday. He is just a nice guy. He's really nice. Today we are our interview is going to be with the wife of Greg Anderson and business partner. Greg Anderson is a senior partner. She is also a partner. I know Greg might say she's a senior partner at the law firm that handled the Kowalski trial. We have her. We have hopefully two of her paralegals, Katie and Kelly. Sorry, I got that wrong. And we have a whole bunch of pictures, audio, song, neat stuff, and just some behind-the-scenes stuff. That's going to happen at noon. That's happening at noon. Let's see. Christy says, super chat, shout out to Eli, recovering fur baby. Oh, I'm one tired mama, but he's worth it. TPLO surgery is no joke. Man, I hope he gets better here soon. Tash, 6 months. So fast. Thanks for all you do, and also for Brandy and Dr. G. Absolutely amazing communities. Tash, you're absolutely right. Two great people and great communities there. Mrs. Brownstone says, one more in the books. Thanks to the OG who recruited me from Long Crime Feed during the LS trial. Maya is an impressive young lady. Wait till you hear her song today. It's really cool. Let's see. Let's see. Is that Lena? Lene? It's Lene. Question, who was Clark Kent in the courtroom? Anyone know? That was Mr. Hughes. Mr. Hughes, and we were talking about an attorney on the defense side. He didn't have a huge role. I think he did more depositions, questioned a couple witnesses during the trial. I don't know what his area of expertise was. Usually they sort of divide and conquer, and that they have one attorney handle all of one part of the case. But I'm not sure what he was focusing on. Yes, David Hughes. Let's see. Oh, nope, the guy in the audience? Was it Maya's boyfriend that was there on the last day? I think he had shorts and a t-shirt on, if you saw him. Okay, let's see. Give me just one moment here. Let's see if we can get this pulled up. try to get this court. Where's it at? There it is. Okay. Okay, we're going to jump to court here just for a brief bit and see what's happening.
So I think it would be, I speak Spanish, so it would be best for me to waive Mr. Raimundo's participation, and I'll fill him in later.
All right. For the waive the defendant's presence, what's your pleasure?
We're ready to set this for exam. We have full discovery, and I could do that November 27th date.
Okay, November 27th at 9:15.
Could we go a little later in the morning? I have a few Frank Murphy matters to handle first.
9:45?
9:45, that should be fine. Thank you, Judge.
Okay.
And may I also say that the complainant will need a Spanish interpreter as well?
Yes, I agree with that. We'll need 2 Spanish interpreters that day.
Okay, thank you.
Thank you.
That's a lot of interpretation going on. If you've got
We continue. Thank you.
2 interpreters.
Thank you, Judge. We'll see you then.
Think how
right,
awkward that
let's go
conversation would be. They're like, why don't we just speak in Spanish?
Go first. Going once, going twice.
Bench warrant.
Moving on, Mr. Riggins.
Good morning, Your Honor. I'm here on Jimmy Tenner and Kelly Mosby.
So you have 2 with me, Tenor.
And Mosby.
Oh, okay.
Mosby, I suspected, were the ASL interpreters.
All right. We'll do Tenor first.
Call case number 230597701 people of the state of Michigan versus Jimmy Tenner. Defendant is charged in count 1, assault with contained weapon, count 2, assault with contained weapon, count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Good morning to your staff. Defender Services by Ken Riggins, P82125 on behalf of Mr. Jimmy Tenner, who appears via Zoom.
Mr. Tenor, tell us your name for the record.
Jimmy Tenner.
What's your pleasure, Mr. Riggins?
Your Honor, I've received paper discovery. Do not know if there's any digital discovery. I have not received that. I'd like to receive the digital discovery, but we'd like to set this matter for a preliminary examination.
Ms. Drain?
Yes, I will. I have one piece of digital discovery, so I will send you that right now.
Okay, let's do November 27th at 11 o'clock.
1 second.
Good morning, Brandy.
I have a matter scheduled with you at 10:15 that day, so
good to have you here.
Okay. We are ready on motion.
Mr. Tenner, I'll be giving you a call later on today.
Thank you.
See, Ginny, we're doing a little court hopping. We're jumping around a couple small courtrooms around the country. This is live.
Assault with intent to do great bodily harm, less than murder by strangulation, count 2, domestic violence, 3rd offense. Defendant has a habitual offender, 3rd offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125 on behalf of Mr. Kelly Mosby.
And Madam Interpreter, your name for the record?
The name is Marilyn Corlett. The last name is spelled Corlett.
All right. Please raise your right hand. Okay, do you swear or affirm to translate from the spoken word to sign language and the sign language to spoken word to the best of your ability?
I do.
Thank you very much. And your name for the record, sir?
I don't. Mr. Mosby is actually in jail. I don't see him.
Oh. Okay.
My bad.
So there's no one for you to translate for us, Miss. All right, what's your pleasure, Mr. Riggins?
Your Honor, I have received paper discovery. I don't know if there's any digital discovery, but actually, I do know there's the digital discovery I have not received. We'd like to set this matter for a preliminary examination, and I'd like to argue bond.
And I am sending you the digital discovery right now. I didn't know who was on this case. So I'm sending it to you right now.
Very good.
Court will continue to plead not guilty and set this matter for preliminary examination on November 27th at 11:15.
Okay, we're gonna jump to another trial.
That date time works for you, Mr. Riggins.
I will be there for you. I have 3 matters scheduled that day, so that's fine.
You said gonna call that the King Riggins Day.
That was turning out to be. And Your Honor, I'd like to speak on bond, if I can.
Go ahead.
Your Honor, I understand the charges in this case. However, from my reading of the discovery, there's 2 things that stick out. One, this seemed to have been a fight between the 2 of them, rather than be a one-sided assault. Number 2, it appears from my reading of this discovery, the complaining witness was adamant he did not want to go forward with any case. My client is he was employed prior to this incident. So we are asking for a personal bond in this matter.
He got assault with a deadly weapon.
So he has a personal bond already, Mr. Riggins, with the
Ag
GPS
assault.
tether part. Curfew 10 p.m. to 6 a.m. $5,000 personal bond.
When
Chief Judge McConaughey on November.
Then I wish my apologies, and then I have no bond argument. I withdraw my argument.
And
How does he have a bond if
I
he's
don't
still
know
in
if
jail?
this has been said, but I think both of the both parties need sign language interpreters.
Yes.
They're gonna have interpreters
All
everywhere.
right, thank you.
2 Spanish, 2 sign language interpreters.
Okay, Mr. Cantor.
Good morning, Your Honor. I'm here for Brandon Blaylock Gibson, who's in the Wayne County Jail.
Did you want to wait on him or waive his presence?
If he's not there, Your Honor, I would ask to waive his presence. We're going to request a preliminary exam date.
Okay. We're ready on Blaylock.
Okay, let's jump over and see if we can check out a new judge here. Let's go here.
Lansing, Michigan, 48901.
Lansing, Michigan.
Apartment 5. Yeah, I think
what's the apartment?
Straight Chisholm.
5. Apartment 5.
Okay.
I think what happened was he looked at the ID, my ID, and wrote down the old address because the sticker had fell off. But when she told me she tried to contact him, because I had contact because I hadn't got nothing in the mail, and I gave her the correct address after it came back to him, and so she didn't get a chance to change it with the course, I believe.
All right. Now, the pretrial is going to be a Zoom hearing as well, and it will not be the same set of numbers that you use today, but you will get the numbers when they mail you the notice, the new Zoom numbers.
Okay.
And as to bond, Mr. Zupke.
Judge, Mr. Williams is employed at Detroit Auto Sales, which is, I guess, a subsidiary or another company of an alliance. So he works in the car industry. He does have some criminal history, but it's been a long time since he's had a contact, and he's been off parole for some time. I don't believe he's ever had a drunk driving case, no outstanding warrants. I know he was shot at some point, and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and he uses marijuana to help with the, I don't know if he was shot at some point and effects of what happened to him, but he doesn't have a card. I told him I would ask for permission to continue using it. I told him that he really should get a card if he wants to, try and use it medicinally. Nevertheless, I did tell him I would advocate that on his behalf. But I'm hopeful the court will give him a personal bond. He's here today. I don't believe he's a threat to society given the allegations.
He does not have a medical card, but he does use marijuana, and he wants to keep using marijuana. So his attorney said, you should get a medical card. Yeah. Judge is thinking it over.
But he's not on probation or parole at this time.
Correct.
If while you're on this bond, then Mr. Williams, you may not use alcohol.
Oh no, my fiance already forbid that. I mean, that's over with. And I ain't trying to lose my fiance.
Fiance forbid the alcohol.
See, Judge, he's on 2 bonds now.
You're going to suggest that if he gets married in court, the judge is sentencing him to life. Okay, no use of alcohol. Testing 2 times a week ETG. Now, what is your phone number, Mr. Williams?
We're going to turn that off.
51.
We don't need to know his phone number.
You're going to need to call pretrial services. I'm sorry, I'm going to change that. You're going to need to call this court's probation department tomorrow to set up the testing. And their number.
Oh, so I have to come.
Or Mr. Zupke will send it to you. Is
Judge,
248.
So I have.
Ready, Judge. Sorry.
So
it's 248.
So I have to come.
You're going to just call them tomorrow. 248-246-3670. And they'll set you up with a testing entity that is relatively close to you. Is your place of employment in Detroit?
So my place of employment is in Lansing, Michigan.
Okay, the company is called Detroit something.
No, it's called Alliance, but we get paid through Detroit Automotive.
Okay, so call the court's probation department tomorrow.
Right.
And they will set up a testing. They have testing resources all over the state that they can line you up with. And I'm noting specifically that alcohol is not, I'm sorry, that marijuana is not prohibited.
I don't know why he has a banana there in the background.
Tomorrow to set it up, to set the testing up.
Okay. Call it anytime.
Call them in the morning.
Okay. Well, I'm gonna have to. I have to work at 2 every day, so yeah, I will.
Specifically noting marijuana is not prohibited.
Does he have a monkey up on the top shelf as well? He's got like monkeys and bananas all over in this background.
You gonna put it out for me?
What's with this lawyer?
And as to the dollar amount of the bond, it'll be $2,500 personal. You do not need to pay that money to stay out of jail. It's a personal bond. In the event you fail to appear as directed, or in the event that you fail to comply with the terms and conditions of the bond, then in that event, you can owe the money.
Right.
Keep in touch with Mr. Zupke.
Mr. Zupke's background is fascinating. He has
All right.
Okay,
there
you're
are
all set. You're good to
legs
go.
hanging down
Thank
from
you.
the top of
All right.
the top shelf. In front of the flag, in front of the stars, it looks like he has a monkey that's sucking its
Hello?
thumb, as well as another small
You're all
monkey
set,
next
Mr.
to it.
Williams.
So basically,
It's got a monkey in a hula skirt down at the bottom.
The marijuana card.
The banana.
I'll message you, Mr. Williams.
All right. So basically, no more. Basically, I can't drink no more.
Correct. You're done drinking.
Or you lose your fiance.
As long as this matter's pending.
Right. I really am too much concerned about drinking anyway because it's a problem within my relationship anyway, and I ain't trying to lose it. Not that I drink all the time, it's just that she just don't like drinking.
Mr. Williams, you're on the record. Just
be quiet.
hang up. We'll talk about it later.
Just hang up, he says.
All right.
Just hang up.
Good luck to you.
Just hang up. Oh, man.
He's still here.
We can still hear him, says the judge.
Got another phone. Let's see who it is.
Yeah.
Someone's come online with a phone number that ends 7120. What's your name?
Alexander Sharp.
What do you have before the court today, sir?
I believe I had one at 9 o'clock, but when I looked on the website, I don't know if it's today or the 20th. I tried to call the phone number on the paper I got, and it just kept telling me payment plan.
What kind of a hearing do you think you have this morning?
I think it's called an arraignment, right?
Do you have a case number?
Yeah, let me go grab the paper. Sorry. I'm just finishing hockey practice.
This judge is
I
super,
don't recall what he said.
super patient.
I thought he said Alexander Sharp. I can't tell you if it ends in an E or not.
Oh, man, Crystal, that takes me way back. I remember those toys.
From this uniform law citation, is it the ticket number or the incident number?
Well, the ticket number starts with a 23.
Yeah, 23RO06489.
So, George waived the arraignment for today, and now it's scheduled with Judge Meineke. Pre-trial is November 20th at 9:01.
This is Magistrate Donald Chisholm.
Okay, you retained counsel. The arraignment was waived, and your pretrial is scheduled for the 20th of November in front of Judge Meineke at 9:01. But your attorney, Mr. George, has all that information.
Okay, so still on Zoom on the 20th at 9:01.
Yes, but it won't be the same set of numbers that you used today. So contact your attorney to make sure that you get the right numbers.
Okay, thank you for your time.
Good luck.
Yes, it's true. Donna Adelson was arrested. That's what I'm hearing. I was not there. I'm just taking the word for it.
Hi, good morning.
Well, Mr. Muhammad, this matter was set for 8:30. You were defaulted at 8:46.
I got to the first meeting ID. I didn't know about that, so sorry.
If the process to set aside the default is something that if you want to initiate that, you have to do it through the clerk's office.
So,
So the matter has been defaulted, and to get a hearing, you need to contact the clerk's office.
so I have to contact the office at the phone call only?
That would be how you'd start the process, yes.
I have
There's nothing else that we can do here. Thank you.
Thank you.
The judge kicked him out. Anybody else, Judge? Are you ready for a break? Let's see if he has anybody else coming up. Don't think he does. Let's see. Let's go back to our other court, see if it got any more interesting. Nope, it's frozen. So let's see who else we have. No. We had a David Wolf from Tennessee. We've got his yesterday's docket. We've watched a trial with him really quick, a quick one with him. Let's see. Let's see what happened with his stuff yesterday. Just one second. So this one is not live. This is yesterday, and we are on camera 2. This courtroom's full. Did we see him yesterday? Man, that room looks familiar. I think we watched this guy yesterday. Yeah, that attorney has quite a bit of personality. His background is quite interesting as well. Zupke. He is sans robe today, I guess. He's doing some light reading on the calendar. See what he has going on. Nothing's happening there yet. Let's jump in with Judge Kenneth King.
Good morning, sir.
Morning, Judge. How are you this morning?
Oh, good. What you got?
We have a Destiny Lucas and a Mr. Mason as well.
Okay, so Lucas is set for November 27th at 11:30 for an in-person exam. Who did you say the other person was?
Mason, last name Mason, first name Matthan.
Okay, they're set for November 29th at 11 o'clock for exam.
Both of them? Okay. Thank you.
One is November 27th, the other is November 29th.
Oh, Lucas is 27th. Okay. Thank you, Judge.
All right, thank you. Have a good day, sir.
Too.
And judges are light workload this morning. Not a lot going on. Everyone's just sitting waiting for somebody to commit a crime, I guess. It's quite quiet. Quite the necktie on the judge here. Anyone find out what case Judge Carroll has starting this week? I don't know. I miss Judge Carroll. Judge Boyd is not live yet that I can watch. She's in Bexar County, Texas, so it's still early over there. They do have a maze of plexiglass there, and I think the bailiff is still trying to find his way through it. He's wandering back and forth, unable to escape. Is that a Steelers? Who does the judge have as far as his helmet there? I can't. It doesn't look like Steelers. He holds very still, but I can see him blinking. So this is definitely live. Thursdays are light. Yeah, what happened? It's Tuesday, and it was over a holiday weekend. You think we still had a backlog from that? It's not frozen. He just holds perfectly still when he's watching the computer. You can see his eyes moving. We're watching paint dry. Let me see if we can find another court where something's happening. Give me just 1 second. Nothing happening in Chisholm. Let's see. Kenneth King, we've got him. Let's see if Judge Kristen Simmons has anything cool going on here. Oh, it's just quiet. It says an attorney sitting there, the judge is sitting there. Nobody has anything going on. See if we can get a parole hearing.
Were you out on supervision before this time?
How many times I was out on supervision?
How many times you've been supervised? Probation, parole, whatever?
This is the first time on this charge right here?
No, any charge.
Out of 25 years you served.
You said you've been in prison 20 plus years. Gotten out on certain occasions and you were on supervision. How many times were you on supervision?
Maybe twice, 3 times.
So you knew the rules.
Yes, sir. Yes, sir.
All right. Okay. All right. Panel ready to vote?
Yes.
Yes. So, Mr. Hitchin, you pled guilty to all 3 of the charges. I do find you guilty of all 3 of the charges. You know, you could have called, you could have reported. If what you're telling us is true, you could have called. I'm very concerned about this domestic abuse battery. Even though the charges were dismissed, you pled guilty to it. I'm not sure I accept your statement of what happened after reading the police report. Therefore, my vote today would be to revoke you.
Yes. Good morning. My apologies.
Hey, Mr. McGlynn, how are you? Come on in.
Here for 8:30. My bad.
It's all right. Come on in.
Where do I?
You can have a seat right there, and I'll bring you up to date as to where we are. Mr. Hitchen, we've had our hearing. Mr. Hitchen has pled guilty to all three of the charges. We've had a little discussion about what happened. He told us basically what happened, and we were basically in the process of getting ready to vote. So we certainly want to hear from you. So
Carl's a good fella, and Stan takes podium.
Just go ahead and announce yourself and
What's
your name into the record?
My name is Daniel McGlynn, McGlynn, Baton Rouge, Louisiana, representing Carl Hitchens. And Carl is fairly articulate, can handle himself. He's got skills. He's got a place to stay. He's got some work lined up. I believe, and if he pled guilty to, and I know that he did not report, he has promised and will abide by any restrictions or rules that the board suggests, which will include any restrictions on his visitations or whether he needs to do coursework or something like that. So Mr. Carl is ready to do whatever the board would like him to do. And I think he deserves it. He's been in for 6 months since he was taken back. The charges have been dropped. The story is a little bit different than the way the police report reads, but he acknowledges there was an argument and is ready to, and frankly, I think this is his only violent or aggressive incident in his record. Probably all I need to say. He's a good fella, and I think he deserves another chance with whatever restrictions this board might want to give him. And he has a very good family support behind him. And if he's going back to Greensburg, I mean, they live on Hitchens Road. They're good people, a lot of educated, solid people. Thank you.
Good, thank you.
Is there any questions I can answer?
No, but in the case of a parole case, we start at 8:30. But in the case of a revocation, we can start as early as 8 o'clock.
Okay.
And
Awesome.
you weren't late. You were timely. We just started early.
I didn't. Francis Abbott, I don't know if he's here. I'd like to meet this fellow. What a nice man.
Thank you.
Anyway,
Thank
he
you.
sent me a text yesterday with a map and.
We hear that a lot, but that means you don't really know it. You think-
I'm glad it's on recording. You got it recorded on YouTube and everything, Fred.
It's only 1/4 of the country. It's quite the odyssey. Thank you very much. And again, my apologies. Carl?
New verification.
Let's see if that swung the pendulum at all.
Mr. Hitchen?
Yes, sir.
Mr. Hitchen, you know, you've been around a while.
Yes,
You
sir.
know what the rules are.
Yes, sir.
And it's extremely important that you report
Yes, sir.
when you're supposed to report. I am concerned about the allegations made in the police report. I mean, you've told us what happened. I'm not sure that that's exactly right. Okay.
Yes, sir.
I'm sorry we didn't have Mr. McGlynn here initially. I think my vote today is going to be not to revoke, in lieu of revocation, following conditions.
Yes, sir.
I want you to go through the work release program for how long?
6 months.
6 months.
Yes, sir.
Get a job, work there. I'd like to see you take an anger management course while you're there.
Yes, sir.
And when you were released,
Yes,
To
sir.
follow all of those rules. Okay, you're backing up a significant amount of time.
Yes, sir.
Okay, so good
Yes,
luck
sir.
to you.
Thank you.
Ms. Pearl.
All right, Mr. Carr, Mr. Hitchison, I'm taking a chance on you.
Yes,
You know,
ma'am.
you already done spent a half of your life in prison, so that's nothing. That's the way I see that. So my vote is the same to do, in lieu of revocation, you complete 6 months of work relief. I do find you guilty of the allegations, and that you report weekly to probation and parole for 3 months after you get out. Weekly.
Yes, ma'am.
Weekly. That means when you just go by the office, you do a form. If your officer in, you see them. If they not, they're not. But just tell the receptionist, I need the doctor. I need you to please write down that I reported in. You
Yes,
just
ma'am.
gonna do your part. And
Thank you, ma'am.
and then after you get through with work release, you pay $100 a month in supervision fees to get them caught up. If you got
Yes,
family support, they can help you get those fees paid. So you need to go in and get caught up. Get in touch. Take care now.
Thank you, ma'am.
Mr. Rocha.
Thank you, Mr. Chairman. Mr. Hitchens,
Yes, sir.
you're a 50-year-old man
Yes, ma'am. Yes, sir.
Yes,
who's
ma'am.
been on supervision at least 3 or 4 times.
Yes, sir.
Why didn't you state to Mr. Marabella when he asked you, do you want to proceed with this hearing? Why didn't you inform him that you had an attorney representing you this morning?
I didn't. I thought y'all already knew, sir.
No, you don't think. When Mr. Marabella asked you, do you want to proceed? You should have said, no, I need my attorney present, and we could have put you back on the docket.
I didn't know, sir.
Now, I'll speak up for yourself.
Yes, sir.
When you're right, you speak up for yourself. Because Mr. Marabella explicitly asked you, do you want to proceed with this hearing? At that point, you should have said, I have an attorney representing me this morning. I'd like to wait on my attorney. Okay?
How was this
Yes,
guy
sir.
supposed to know that his attorney wasn't there?
Mr. Hitchens, you pleaded guilty to all the violations.
Yes, sir.
Because of your demeanor this morning, which has been very, very cordial, I'm going to agree with my colleague and in lieu of revocation, a 6-month transitional work program and take anger management while you're in the transitional program.
Sir.
Follow all rules and regulations, sir.
Yes, sir.
You're 50 years old. This is probably going to be your last chance. If you're ever incarcerated again for a felony, you may spend the rest of your life in prison.
Yes, sir.
Good luck.
Thank you, Mr.
Thank you,
Rocha.
sir.
Mr. Hitchin, you have received 3 votes in lieu of revocation. You're not being revoked today, but you've got to do some things before you can get out. 6 months in the work release program, anger management. Once you get out, you need to report weekly for the first 3 months, and then to pay at least $100 per month towards your supervision fees.
Yes, sir.
Mr. Hitchin, you're correct. Mr. McGlynn's brief was in our packet of work. I just didn't know he was going to be coming today. So, sometimes when you get up there, you get nervous, you get confused, and I'm sure that that's the case with you. So good luck to you.
Thank y'all, sir.
You're welcome.
Okay, so that was interesting because this guy was going to get
When that
revoked.
take place?
This guy was going to get revoked. He was going to get sent back to prison. And he had already said his piece. He'd already said, here's the story. Here's what happened. They didn't believe him. And then his lawyer shows up mid-vote. One of the parole board has already voted. The lawyer shows up. And the guy's already said, we're going to revoke you. And the lawyer's like, oh, sorry, I was late. He's a good guy. He's got a good family. that's it. And they're like, all right, well, based on that, we're going to change our opinion, and we'll go ahead and, in lieu of revocation, we're going to make you just do a couple things to stay out. So, one more time to stress the importance of having a lawyer to represent you. This is why you need an attorney, says Heather. Yes. Let's see. We've got. Let's see if there's anybody else in. Let's see. We've got. He's not doing anything right now. Let's keep an eye on that. See if anybody else is live. I guess Tuesday morning is the day the judges just sit there and look pretty. It's a very interesting system we have, Christina. Correct. Reminder that at noon today we have a huge interview. We have Jennifer Anderson, who is the wife of attorney Greg Anderson, who represented Maya and the Kowalskis in this trial that we just watched for the last 9 weeks. She's going to be on. Hopefully we'll have both of her paralegals with us. Katie and is it Kathy? I keep forgetting the names. They're very similar. So let's see here. Kelly and Katie. And so we're going to have them this afternoon. Also, we have they've provided new audio, new images, new recordings of Beata. We're going to play some of that, and I've edited it into a song, basically a little slideshow to the music that Maya wrote, the song that she wrote while she was in J-Hatch. So we'll have that coming up here this afternoon as well. The judge is like, what are you doing in my courtroom?
Oh dear, I knew this was going to happen. Your Honor, I'm on the juror Sean Sherrill matter. I apologize for the mishap I've been having with my connection.
Everybody wants to real.
And he wants to hold the exam.
We call it.
Calling case number 2305-978-501. People of the state of Michigan versus Dormstein Sherrill. Defendant's charge name count 1 and 2. Assault with intent to do great bodily harm less than murder or by strangulation. Count 3, domestic violence. Defendant has a conviction for notice, mandatory 25-year sentence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Sean Sherrill.
Are you waiving his presence?
Yes, Your Honor, I do waive his presence.
What's your pleasure?
Mr. Sherrill is requesting an examination.
Court will continue the plea of not guilty and set this matter for preliminary examination. House November 27th at 9:15.
The 27th at 9:15 works.
Okay. November 27th, 9:15. Bond will be continued.
Thank you. Have a good day.
Thank you.
Bye-bye, everyone.
Bye. Got 3 bailiffs in the courtroom now.
That's it for you, Ms. Drain.
Yes, that's it for the PCCs. There is a case up on Friday, People versus Kendall Hosendove, and I did have an issue I wanted to address with the court. I did email defense counsel Rosemary Daher to see if she could Zoom in this morning. She said that she was busy this morning, but she would try maybe about 10:30, 11. So I know that you have exams, but I'm going to either, I think I'll just put YouTube on so I can watch and see.
Just
if
Netflix
if
and
she
chill.
does sign in, if we could address an issue later on.
Okay, no problem. I don't think my time is gonna go though.
Oh, okay. Okay, very good. Thank you, Judge.
Thank you.
Okay. The parole board hearing has another revocation coming up. It's just taking a minute to start. I think that's what she was saying, Evie. She's just gonna pop on, watch some YouTube because she doesn't have any work going on right now. Judge Carroll has a court case that's supposed to start this week. I think it's in jury selection right now, but I don't know what trial that is. Yes, Jennifer Anderson, not Aniston. Jennifer Anderson will be on the show this afternoon in about 2 hours, 2.5 hours. Ooh, DeSanto's live? Hang on one second.
So whatever submit, depending on what the court permits, I wanted to bring that to the court's attention. So I would be asking for a personal bond. Thank you, Judge.
All right, so you've had a couple of cases here before, haven't you?
Yeah, yes.
And you currently on probation here?
No,
Are you on probation anywhere?
no.
He successfully completed a height of probation and a 7411 probation.
Is that out of Trenton?
I think it was Taylor.
Okay, anything occur from the matter in Trenton from June
No, man. I don't think so, no.
regarding felony or weapons offense?
Oh, yeah, but I never got charged for it. They let me go with no charges.
All right.
That doesn't
And so
impress
you
the
have a
judge.
valid medical marijuana card?
Yes.
When's the last time you used marijuana?
Just yesterday.
All right. You're not currently under the influence of anything, are you?
No, oh, no.
And how'd you get here today?
I Ubered.
And do you work, sir?
Yes.
Where do you work?
Called Rosa. It's a warehouse. I work midnights. It's a temp service job.
Why was it that you didn't appear in court here, sir?
I couldn't get a ride at the time and I had no money for Uber or anything. And then the other time I was really sick.
And Judge, I explained to my client that excuse going forward will not be satisfactory, nor was it satisfactory for him missing the court dates. That regardless of getting a ride or financials or sickness, he at least needs to contact the court and make arrangements to not abscond.
Thank you. court will order a $5,000 personal bond not to possess or consume any alcohol or drugs that are not prescribed. Have a seat in probation. Somebody will be with you shortly, sir. We'll see you back on December 18th.
Thank you, Judge.
All right, have a good day. Next one, Hall.
Yes, Judge.
Okay. Matter of Johnson Hall, 231723A.
Judge, would it be not public, we have to go off YouTube?
No. Why are we going off YouTube?
Oh, okay, yes, just one moment.
So now we won't get to hear it. This one is off YouTube for some reason. Could be a minor. Could be a minor. That would be why. Gentleman, looks like he's in custody. The jail. He's not. He's not happy with his hair. Keeps adjusting it. We're still waiting for the case with the gentleman from the WCSO, the jail. He has not had his appearance yet. The judge did mute herself for this particular appearance, probably because it's a minor, and so they've turned the camera off as well. We're just waiting to for this one to end. See what comes next. I think a parole hearing just started.
With like with a voice call, video call, every like week or so. Every time I changed like a hotel, she'd have me like contact her with a new address where I was working at in the area.
So when you came back to Louisiana, what address were you supposed to be staying at?
At the 1325.
And why were you staying in Tankerville instead of where you were supposed to?
I was living with my girlfriend at the time, and we had problems, and I left out and went to stay with a friend.
So you were in contact with your parole officer the whole time that you were in Florida, and you knew the procedure, but when you came back to Louisiana, you just did what you want to do and stayed where you want to stay.
Yes, sir.
Did you have your parole officer's telephone number?
Yes, sir.
But you are all purposely trying to avoid your parole officer and harassing a young lady who's trying to raise your daughter.
Yes, sir.
Mr. Chairman.
Yes, sir. Is there anything you'd like to say, Mr. Semino, before the board votes?
I actually just please have a little leniency on me. I'm trying to get home, man. That's all. I know I'm messing up, and I don't plan on messing up before. I'm just over with from it.
Okay, thank you.
Thank you.
Mr. Chairman, Mr. Semino.
Yes, sir.
I find you guilty of violating conditions number 3 and 4 of your parole supervision contract. Therefore, I am revoking your supervision.
Thank you, Ms. Brochet. Ms. Wise?
My vote is the same for the same reasons.
Mr. Semino, you received 2 votes to revoke. Mine is likewise. Your parole has been revoked today. Good luck to you, sir.
That's the last one.
Okay, we can adjourn at Iberville Parish.
Thank you.
Wow, he wasn't too happy about that. Let's see if they start the next one right away. And they're not, so let's see if oh, we got a bailiff walking around. Deputy Holman with a nice beard. Oh, he's driving. He's a passenger seat. Judge Boyd starts in about 10 minutes. We'll keep an eye out for her. See if she has a regular docket. I feel like the judge is looking right into my soul. Okay. Are we back on YouTube? There we go.
All right, Deputy Holman. Good morning. Which matter are you here on?
I subpoenaed for Mr. James Brunner.
Okay, I don't know that he's here yet, but we will keep you posted.
All right, thank you.
All right, thank you. I'm just going to I'm going to mute you and turn off your camera. All right, where's Mr. Westmoreland?
Camera?
Now compare this attorney with Zepke. He's got like a bare coat rack is all he's got in his background. Clearly he can up his game there.
Yeah, I'm on.
Oh, there you are. Okay. All right, we are going on the record in the matter of the City of Wyandotte versus Logan Malone, 232249.
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Malone. Mr. Malone, would you unmute yourself and state your full name for the record, please?
Mr. Malone, can you please unmute?
Yeah, sorry, Your Honor. Logan Malone.
All right, thank you. Today is the date scheduled for sentencing in this matter on your client's plea to retail fraud. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, I have, Your Honor, and at this time it is factually accurate. There's no additions, deletions, or corrections. I would like you to know that Mr. Malone has been in custody since October 17th. He is looking to get out of custody so he can get back to work. He is apologetic for his actions, and he did take responsibility. He's just looking to get this behind him. I would just respectfully request credit for time served on Mr. Malone's behalf.
All right, the court will note that restitution is being requested from Rite Aid in the amount of $29.32.
And he will be prepared to pay that upon release.
He's been in jail for
And sir, you are also
a month over a $29
on
theft.
probation currently out of
Probation.
Washtenaw County, correct?
Yes, Your Honor.
I can't hear you, sir.
Yes, Your Honor. I'm currently still on probation in Washtenaw County.
And what are you on probation for out of Washtenaw County?
It is a misdemeanor, disorderly conduct, Your Honor.
Okay. And so you have a criminal history that stems back to 2016. And then in 2018, you have domestic violence. 2019, felony interfering with electronic communications. 2019, domestic violence, second offense. 2021, fleeing elude third degree. In 2022, disorderly person, and now this one.
Yes, Your Honor.
He does one a year, but he missed one in 2020.
And
He was slacking in COVID years.
you're currently on probation, and you are down here in Wyandotte and violating probation.
That's correct, Your Honor.
I can't hear you.
That's correct, Your Honor.
And so what are some of the conditions of your probation?
That I not take any, catch any new cases, Your Honor.
And you did.
Okay, what about alcohol consumption?
That is not one of my orders. I just sent an email once a month and say how I'm doing, and I'm not reporting.
You're non-reporting probation? With your criminal history, you're non-reporting probation?
That's correct. All I do is send one email to my PO.
I'm sorry.
All I do is send one email to my PO a month and tell her how I'm doing. And then she just takes my word for it, and then I move forward.
Well, perhaps, sir, that might be some of the problem as to why you continue to violate the law. And as you don't appear to be learning from your behavior at all.
I'm sorry, Anya, but I definitely have learned. I'm not catching no more domestic violences. I'm not being quick to anger no more. And the only thing that's really been bothering me is just stealing. So I gotta nip that in the bud and then move forward.
It's just that theft thing. That's the only thing that's left. I fixed everything else.
I'm currently, whenever I get released, Your Honor, I'm currently going to go to a treatment program and, get right. I just had 7 months clean from September 3rd to May 5th, 2023.
Well, sir, that's commendable to be on this, have 7 months clean. But what the court's going to do is take into consideration your criminal history, the fact that you're currently on probation, and that you don't appear to be a good candidate for probation. The court's going to order 60 days jail credit for 29 days.
All right, thank you so much,
You
Your
have a
Honor.
$200 fine. I'm sorry, what's that?
Thank you, Your Honor.
$200 fine,
She's not
$100 screening
impressed.
assessment fee, $200 for the cost of prosecution, crime victim assessment fee, $75, justice system assessment fee of $50, restitution, you have $29.32.
Doing the
So
math.
$654.32. You need to contact the 27th District Court within 48 hours of your release, or once you're released, to set up a payment plan.
Okay, Your Honor.
Just saying, you'll have to steal a lot of stuff to pay for that.
Anything else, counsel?
I won't wait. Did I
Not
say
this
that out
time,
loud?
Judge. Thank you.
Great, thank you. Good luck to you, sir. We're going to be off the record.
That $29 charge,
Your Honor, I have James Esther.
a $29 theft
Okay, thank
turned
you,
into a
Mr.
$650.
Paul, that's one of yours. Mr. Eister is one of yours. So do you have, yeah, is Mr. Moorhead yours?
Mr. Moorhead's mine, Judge. I can come in the court.
Okay. Okay.
I'm here, Your Honor, I'm Mr. Brewer, we just got the link.
Mr. who?
Brewer, it's opened.
Oh, that's right.
He
Okay.
was not on the register of actors or on the docket.
Yes, he is.
He is now,
9 a.m.
and he's here because when I was reviewing the schedule, as of yesterday, he wasn't.
Oh, so the
However,
coat
he
rack
appeared
guy
today.
just walked into
Okay,
court.
thank you.
Unfortunately, because of that, we don't have our witness.
We do. The deputy's on this.
We have that witness, but we don't have our witnesses. Yes. I guess to adjourn, Your Honor.
Well, on the 31st, I indicated that it was going to be today at 9 a.m.
That is correct, Your Honor. And as I kept reviewing the docket, it was never on the docket when I came down to do my review.
Okay, all right, just a moment.
So she told him when the court case was. The lawyer kept checking the calendar. It wasn't on the docket, so he didn't call a witness. And so now...
No reason, Your Honor. Just, he hasn't, in fact, he's supposed to be in probate court in about 5 minutes. Another matter.
Well,
I mean, we could.
Where's that? All right, let me check on it first for a moment.
Thank you.
I would say if you have a court date, that is your most important scheduling thing. I would look at that every single day and know exactly when it was and prepare myself and be there on time no matter what. Because not showing up to court just causes a lot of problems in your life. Follow and respect. I'm trying to think who we followed in Illinois. I can't think of one off the top of my head. Let's see if we can find Judge Boyd, see if she's working yet. Ooh, she's live. She just got live. Here we go. Here we go. Okay, here we go. Let's jump to Judge Boyd, shall we? This is interesting and all, but
the way the day is going to go today is we're going to start with closing arguments, and there's nothing worse when you're in the middle of your closing argument and a phone goes off.
I hope you have your phone silenced because Judge Boyd is not putting up with it today.
Diana, I'm going to do my best not to veer off my diet. But since Norma just sent that message, she said the McRib is back.
This just
I'm going to try not to. The McRib is my weakness, even though people say it's not real meat. I don't know if it's the special. There's something about the sauce. Is it like the movie with Charlton Heston when they say, it's the people? But at least it's not green. Hello, George.
Morning, Your Honor.
Good morning. The state had asked for 15 minutes. Are you all okay with 15 minutes, or did you need more than 15 minutes?
That's fine by me. Let me see what Adam wants.
All right. And Deputy, did you make sure Mr. Dixon is brought up? All right, can you bring him out? Yes, we're ready.
Yeah, this we didn't follow this whole case. We saw little bits of this with a witness who didn't want to say he saw anything. I believe it's a murder trial. But let's listen to the closing arguments
We're
here.
just waiting for them to bring him out and waiting for Adam.
Adam advised me there's some real bad traffic going on, so.
Okay. All right, while we're waiting for Adam, then I am going to call the docket. When I call your name, let me know that you're here. Damon Thomas is in custody. Christopher Robles, custody. Alexander Castro. Alexander Castro. John Albert Garcia, custody. Andrew Arnett. Andrew Arnett. Deputy McKee, I'm going to give everybody till 10:30 today because I'm not sure if Lance called them and said we were starting at 10. John Albert Sanchez.
Present, Your Honor.
Thank you. Anthony White. Anthony White. Josh Shanae Caldwell. Thank you. Vicente Navarrete. Thank you. And custody is Joe Perez. Lisa Marie Anderson. And custody is Jose Carrion. Joel Singleton. I'm sorry, Singston. Mari Amanda Fuller. Thank you. Isaiah's, I know I'm mispronouncing that.
Yeah, no.
Thank you. I'm going to work on that. There's a lot of vowels going on. I have to figure out what to do with them. All right. Christopher Robles is in custody. Jose Casa de Mata. Thank you. Deputy Mejia is never helpful with me with the pronunciations. Terrence Bowie. Terrence Bowie. Larry Nunez is in custody. Heather Martinez. Heather Martinez. Kimberly Dixon is in custody. Christopher Jones. Custody. Jaro Rivera.
Here.
Jasmine Hunt. Robert Lopez. Tanya Ortega. Custody. Mark Costa. All right, thank you. Joseph Harris and Vernon King is here. And Katsakote Martinez is in custody. All right, is there anyone present whose name was not called or you came in late? All right, we're going to start over here. Batman. I'm sorry, what?
Did she
All right,
just
do
say
you know who
Batman?
your attorney is?
No.
All right, just give us some, do you know your SID number?
Yes.
Okay, what is your SID number?
His number is 1187447.
All right, thank you. Who else over here? Yes. Do you know who your attorney is? Or do you know your SID number? All right, just give it, have you met your attorney before? All right, just give us a moment. Over here? Joey what? Do you know your case number, SID number?
1179950.
All right, thank you. Yes. Castro what? Do you know your case number, SID number?
855223 for the SID.
All right. So anyone else coming in late?
Terrence Bowie, Your Honor.
All right, thank you.
Thank you.
Deputy, does he need to be in custody? All right, Mr. Bowie, if you'll come forward, please.
Yeah.
All right, so the four people who, if you haven't had contact with your attorney, we're going to make sure that you have contact with your attorney, okay? Is there anyone else? All right, so this is the way the morning is going to go. It's going to be a little chaotic, but sometimes chaos is great. We are waiting for the defense attorney to appear. And once the defense attorney appears, we're going to do closing arguments before the jury. So everyone, please make sure your cell phones are off or on silent, because there's nothing worse when you're in your groove doing your closing argument and somebody's cell phone goes off. So let's be kind to the attorneys and not have our cell phone on. Once the state brings down their boxes, you all will be able to confer. So right now you'll notice family violence is not here. The reason why they're not here is because we're supposed to start at 10 with our docket. So if you all would like to go downstairs, stroll in the cafeteria, you're more than welcome to do so, but you need to be back here at 10 because we are recessing at noon. And depending on what happens with this jury, we may end up starting punishment. And if we start punishment, we will take you over a break. We will not reset you because we are in trial. Today is Tuesday. It's going to be a great day. The reason why it's going to be a great day, because it's not Monday, it's Tuesday. So we have something to be thankful for. And we are closer to Friday than we were yesterday. So that's where we are on this docket. Attorney's not available to confer yet. So please enjoy. And I will call, you want me to call them up for you?
Looks like we're all headed down to the
thank you so
cafeteria.
much. And if they haven't spoken to their attorney, I'd like for them to see if we can get the attorney here so the attorney can speak. All right, thank you so much.
Good morning, Judge.
Good morning. Yes.
Mr.
Bowie.
Mr. Bowie, you know he had those cases that he has in the process. And can they take you out to satellite to the magistrate is there?
Oh, they're short. So,
Would you be able to magistrate?
yeah, I can magistrate him.
Is that the bond?
The bond setting is going to be a little bit difficult, but I tell you what, if you will wait until they finish their closing arguments, I'll be able to do that at that time.
Great.
Okay.
Thank you.
You're welcome. George, you have an idea of his ETA?
Let me try to call him. He's here, Judge.
Oh, awesome.
Just come in and have a seat. Morning, my apologies, traffic was terrible.
Oh, no, no problem. So Adam, are you okay with 15 minutes? Or do you want more?
I'm thinking 20, Judge.
Okay.
What do you think? 20, I feel better with 20, Your Honor.
All right. Does anybody want a time announcement or a warning?
Judge, you just give me like 5 minutes.
Okay, 5 minutes.
Same with us, Judge, 5. We may not use.
Okay. All right. Well, the jurors here. Is there anything you all need before we call the case?
Anything? No, Your Honor, nothing I can think of.
Okay. Yeah, if you can line them up. All right, everyone. Need silence.
Jason.
And I know no one would do it, but there's not to be any outbursts during the closing arguments. Sometimes people may say stuff that you don't like, but there's not to be any outbursts during the closing arguments. Court is calling 2022 CR 9807, State of Texas versus Vernon Dixon. Can I have parties announced for the record for the state?
Jason Garahan and Danielle Escobar for the state, Your Honor.
Adam LaHood and George Schaefer for the defendant.
And are you Mr. Dixon?
Yes, ma'am.
Have both parties had a chance to review the charge of the court or the jury charge?
Yes, Your Honor.
We have, Your Honor.
Any objections?
From the state, Your Honor.
None from the defense, Your Honor.
All right. Well, Deputy Mejia is lining the jurors up and we will start.
So we're gonna listen to the closing statements in this case, and then it goes to jury deliberation. At that point, we're gonna have a little bit of a break, and then start 12 o'clock with our interview this afternoon with Jennifer Anderson, who is the wife and law partner of Greg Anderson, who represented Maya in this trial, this last trial, not this one, and it's gonna be amazing. So bring your questions. Just make sure you block out this afternoon for that. It's going to be wonderful, wonderful, a lot of fun. Feel much better, Southern Gal. The defendant is just off screen on the right-hand side of the table. He's standing, so his attorney was the one that was late because of traffic.
All right, everyone, please be seated. All right, you all know that the courtroom is slightly crowded. That's part of my docket today, but it has nothing to do with this trial. Does everyone understand? All right, I'm going to read to you what's called the jury charge, a charge of the court. You do not have to memorize it because you will be given it once you go back to the jury room. Members of the jury, the defendant, Vernon Dixon, stands charged in count 1 of the indictment with the offense of murder alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 2 of the indictment with the offense of unlawful possession of a firearm alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 3 of the indictment with the offense of tampering with physical evidence alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. 1, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2, our law provides that a person who has been convicted of a felony commits the offense of unlawful possession of a firearm if he possesses a firearm after the 5th anniversary of the person's release from confinement following conviction of the felony, or the person's release from supervision under community supervision, parole, or mandatory supervision, whichever date is later, at any location other than the premises at which the person lives. The offense of possession of cocaine under 28 grams is a felony offense. 3, a person commits the offense of tampering with physical evidence if, knowing that an offense has been committed, the person conceals a thing with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation of or official proceeding related to the offense. The offense of aggravated assault with a deadly weapon is committed if a person intentionally or knowingly causes bodily injury to another while using or exhibiting a deadly weapon, or if a person intentionally or knowingly causes serious bodily injury to another. 4, individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Possess or possession means the actual care, custody, control, or management of property. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. 5, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, With respect to the evidence submitted in this case concerning the defendant having been previously convicted of a felony, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant was in possession of a firearm on or about the 31st day of March 2022. 7, count 1, murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, did intentionally or knowingly cause the death of an individual, namely Avante Boyce, by shooting Avante Boyce with a deadly weapon, namely a firearm, or the defendant, Vernon Dixon, with intent to cause serious bodily injury to an individual, namely Avante Boyce, did commit an act clearly dangerous to human life that caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm, then you will find the defendant, Vernon Dixon, guilty of the offense of murder as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 1. Count 2, unlawful possession of a firearm. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, having been convicted of the felony offense of possession of cocaine under 28 grams on the 20th day of July, 1992, and cause number 1991 CR 0678 in the 187th District Court of Bexar County, Texas, did intentionally or knowingly possess a firearm after the 5th anniversary of Vernon Dixon's release from confinement or release from supervision under community supervision, parole, or mandatory supervision following conviction of said felony at a location other than the premises at which Vernon Dixon lived, to wit, a public place, then you will find the defendant, Vernon Dixon, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 2. 9, count 3, tampering with physical evidence. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, knowing that an offense had been committed, to wit, aggravated assault with a deadly weapon, did intentionally or knowingly conceal a thing, to wit, a firearm, with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation or official proceeding related to the offense, then you will find the defendant, Vernon Dixon, guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 3. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You're instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet, chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which
really
is
like how
not
she
shown
reads
by the
these.
evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case.
She said
After
both.
argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror was certified thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict. If that can be done without violence to the individual judgment, a unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and jury forms are attached. State, are you prepared to proceed?
Yes, Your Honor. I very briefly wanted to cover a few things that are found in the jury charge. You're going to hear from the defense, and then you're going to hear from Jason one last time before we're done. So, as the judge mentioned, there are 3 counts of this case: murder, unlawful possession, and tampering with physical evidence. Now, each of these are independent of one another. So you have to consider, did the state prove the elements in each count independent of one another beyond a reasonable doubt? So let's start with count 1, murder, separated into 2 paragraphs. Now, what that means is that it's paragraph A and paragraph B. One juror could say that they found beyond a reasonable doubt paragraph A, and then the rest can all say paragraph B. It's just that it's unanimous that it's one or the other. So let's start with paragraph A. It's on or about March 31st of 2022, Vernon Dixon in Bexar County, Texas, intentionally caused the death of Avante Boyce by shooting him with a firearm. Now, there have been many witnesses who have come forward and said that those events happened. They've explained that through their testimony. And again, it's each individual part. It's the date, where, who, shooting, intentionally causing death by shooting a firearm, which is a deadly weapon. That's what everyone agreed on. So paragraph B, it's again, on or about March 31st of 2022, the defendant Vernon Dixon, with intent to cause serious bodily injury to Avante Boyce, committed an act that was clearly dangerous to human life, shooting a firearm at Avante that caused his death. Now again, it's not that he intended to kill, it's that he intended to cause serious bodily injury. How do we know that? He shot at him with a gun. You are intending to cause serious bodily injury when you do that. And it's clearly dangerous to human life because you can't say what that bullet's going to do to a body once it hits. So then moving on to count 2, it's unlawful possession of a firearm. So the defense in States 39 stipulated that the defendant was convicted in, it was 1992 CR 0678. So that's already been stipulated to, that he was convicted. Now it's looking at, did he possess a firearm? Many witnesses came and said he was the one who had the gun. Next, was it in a public place? Well, he didn't live at that apartment complex. He had access to it. Several people had access to that apartment complex and that patio area. So it was a public place. Then the next one, it's count 3. It's tampering with physical evidence. Now, a witness came and said, it was Donald Neely. He said that after the shooting, Vernon handed him the firearm. And that's why the firearm wasn't found. He handed it off with the intent so that it couldn't be found. When you hand it off to someone, you're not saying get rid of it. Now, again, each of these are independent of one another. It's, did the state prove each count beyond a reasonable doubt? Now, you aren't going to get any of the police reports that have been referenced to by several of the witnesses. That's not going back there. You can't let bias or sympathy play a role in your determination today. The question you have to answer is, for each count, did the state prove these elements beyond a reasonable doubt? We have. We brought many witnesses to say what happened that day and how Avante lost his life. We have proven on each count that he is guilty. Thank you. And state reserves all the time. Thank you.
All right, defense.
Yes, Your Honor. May it please the court, counsel for the prosecution. Good morning, how are y'all today? The first thing I want to say is the charge of the court. I'll remind you that goes with you to the jury room, so don't worry about trying to remember what we said, what like that. It's all in here. The judge has the law. The lawyers have their duties. The state wants to convict Vernon Dixon. Okay, they want you to find him guilty. Remember that what we talk about here, we lawyers, is not evidence. Okay, evidence is that which the court admitted from the witness stand. We all have our views, we all have our opinions, but what we say is not the evidence in this case. The real bottom line here is, what does the evidence say? Okay, what does the evidence say? The state produced a video in this case, and you have to look at the video. And the state has alleged that the murder occurred at 3 o'clock with 49 minutes and 41 seconds. Look at the video, because some of the witnesses said, oh, he did it. And some of the witnesses say, we don't know who did it. What's that? That's a reasonable doubt. That means that the state has not proven this case beyond a reasonable doubt, as they are required to by law. The video. Some of you think maybe he did it. And some of you are wondering, did he do it? That right self, that in and of itself creates a reasonable doubt. If you don't know who did this, then you must find him not guilty. I've looked at the video. Y'all have looked at the video. Look at the video again, and in your own mind, decide, do I see Vernon Dixon shooting the gun and causing the unfortunate death of Avante Boyce? I can't tell you that. You have to decide the facts in this case. The bottom line is, you have to decide the facts, and you have to decide, maybe he did it. Maybe he didn't. What we don't know is that there's at least half a dozen people there present. We don't know who shot Avante Boyce. And if we don't know it, you don't either. That, ladies and gentlemen, is the reasonable doubt that you have to go back to the jury room and make your own mind up. I'll remind you of some of the instructions in the charge. Each of you has to make up your own mind. I don't want you to say, well, I'm going to go with the rest of the jurors because I'm in the minority and they're a majority. Each of you has to make up your own mind. We want to go ahead and thank you for your service in this case. We want to thank you for your verdict. We look forward to hearing back from you.
May it please the court, state. Good morning, ladies and gentlemen, and thank you all for being here. It's been a long think this whole thing started about a week ago, and we understand that this was not an easy sacrifice for anyone, but without you, this whole process can't happen. We're here today, State of Texas versus Vernon Dixon. Mr. Schaefer told you is correct. Burden of proof in a case. The burden of proof is always on the state to prove, and they must prove each and every element of every offense. If you have reasonable doubt as to anything, any of the elements, whether this happened in Bexar County, a date, any of the elements in there, then you must return a verdict of not guilty. And that goes for all 3 counts of murder, felon possession of a firearm, and tampering with evidence. Remember, we talked about more dire levels. We have reasonable suspicion on the very far end. That's enough for a traffic stop. Beyond that, we have probable cause, which is burden to arrest. And that's less than 50%. Beyond that, we have preponderance of the evidence, which is just a little bit more than 50%. Beyond that, clear and convincing evidence, which is excuse me, you see this in a CPS case, Child Protective Services. It's enough to remove a child from a parent's home and place them with a new family. And then beyond that, we don't know exactly where this level is. We leave it to each and every juror to decide for themselves, is beyond a reasonable doubt. It is the highest burden that we have, and it's the highest for a reason. Because what you're deciding here today is life or liberty for somebody. This is the only kind of offense, criminal offenses, that can result in somebody being thrown in prison, thrown in jail. And for that reason, our laws say that you must be convinced beyond a reasonable doubt. What is presumption of innocence? I think we told you at the beginning, it's the only presumption that carries through a verdict, through a jury trial, all the way until a verdict is rendered. As he sits there today, Vernon Dixon is presumed innocent. And I'm going to suggest to you that the state failed in their burden to prove beyond a reasonable doubt that he is guilty of any of the offenses today. And why is it important? It's because it's the only presumption we have in a criminal case. It's what protects us all. Again, we talked about three possibilities: guilty. That's an analogy. You have a horse race and it's a runaway. You have guilty, not guilty, and then you have this last one, not sure. You look here, if you remember, it's like a horse race in the moment, kind of hard to tell. You know, somebody won by a nose. If you are unsure, if you're left there with a doubt, that is your doubt. That is your reasonable doubt. And not sure is not guilty. I'm going to talk about what you have. You have a blurry video, and Mr. Schaefer mentioned it. Go back and watch the video. It's admitted in evidence. You can watch both of them. Take a look at it frame by frame if you want and see. You do not see the shooting on that video. You cannot tell who killed Avante Boyce that day. And uncertainty is reasonable doubt. I think I told you in opening that this is a case of missing pieces. The state is going to present evidence, but they're also going to have a lack of evidence. In this case, we have no fingerprints, no weapon, no GSR. Do you remember GSR? We had, I think, 3 witnesses talk about it. Gunshot residue. You remember what Dr. Kanan said? Said that at a close quarter shot, something that happens so close range, you should see GSR on the burn wound. Even at a close range, it should be there. And you'll have the photos. It was not there. So does this match up with the state's theory that Vernon Dixon in close quarter shot and killed Avante Boyce? I'm going to tell you it does not. Again, you had multiple people under that pavilion, multiple people that could have been the shooter. Talk about witnesses. You had Versa Austin, aka Juicy. The state had him on the stand for a long time. At one point, they were arguing with him. He's about 15, 20 feet away from the car. He says very clearly, I did not see who shot him. And he's there with the perfect vantage point. You have Mr. Carl Cunningham. He said he saw something, but he's across the parking lot. Remember the photo they presented. That's also an evidence to you guys. He sees something going on. He hears a shot, but does he have a clear view of what actually happened? And my suggestion to you is no, he does not. Donald Neely goes by Raven. Said Vernon handed off the weapon to him, yet he's remained silent about this for over a year. He says something along the effects of, I didn't think it was important. No one ever asked me. Well, does that make a whole lot of sense? If you had something as important evidence, he admitted, yeah, I knew there was a shooting. Yeah, I knew something went on. Oh, by the way, this happened, but I didn't bother telling anyone about this until just a week ago. Why does that make any sense? And the answer is it doesn't. As for motives, we don't know. The state's not required to prove motive, nor is the defense. And lastly, we talked about Dr. Rajesh, Said 2 wounds, 1 fatal. we're not questioning the cause of death here. This was a gunshot wound that killed Avante Boyce. However, what was missing? No powder burns on the skin, which again, even through clothing at a close range with a firearm, 2 shots you should have seen, and we did not see it. This refutes the state's theory that this was a close range shot. And does this match up with the video? Someone as close as Vernon could not have made that shot. However, there's other people in the pavilion in that instant that very well could have been the shooter. Think about just the overall mood that day. There's high flying emotions and anger, and that makes for questionable testimony. We're going to come back to that. You heard that there's a fight. The girls are all fighting. And who's trying to break up the fight? You have Vernon, you have Avante, and they're breaking this whole match up. Everyone's in the car. Things seem to be cooling off. And then for seemingly no reason, they want you to believe that Vernon gets out and shoots and kills Avante in cold blood. Ladies and gentlemen, that doesn't make sense, right? We're going to tell you, don't leave your common sense at the door here. Nothing about this murder, about the offense here, the way the state has presented it, matches up to the evidence or makes sense it just doesn't pass the smell test. And remember, uncertainty leads to reasonable doubt, and reasonable doubt must lead to an acquittal. I think I told you at the beginning, this is a case of what's missing, and what's missing in this is absolutely crucial, right? You have bits and pieces of a puzzle, but you don't have the full puzzle. And you cannot convict, you cannot follow your oath and convict Vernon Dixon based on only partial picture, not in this case. We're going to ask you to return the only verdict which makes sense, and that is not guilty. I just want to talk to you a little bit more. Like I said, you've heard from a total of 15 or 16 witnesses in this case, and yet you're left, in my opinion, we're left with more questions than we have answers. We have a lot of questions left on this case. And again, we told you certain facts are not in dispute. Avante Boyce is dead, and that is a tragedy. No one ever deserves to lose their life. You heard from Evie Lewis, and it was the first or third witness that was called after 2 officers. She testified there's a fight, only 2 people trying to break it up. And again, does this make any sense at all? That somebody just randomly gets out and shoots and kills a person that just moments before they were working with? Or does it make sense that possibly there's a shooting, someone else is a shooter, and you just kind of jump to a conclusion? You make an assumption, yeah, this is the person that shot him. Think about Evie's vantage point. Back seat, Vernon's up by the front of the car. I'm going to suggest to you that she heard a shot, your brain puts 2 and 2 together, and it just doesn't match up. We talked about Versa Austin. He's standing there 15, 20 feet away. They had him on stand a long time. At the end, he had to say the same thing. Vernon did not shoot. He did not see Vernon shoot. And that's important. He's an eyewitness. He's right there. And he has a vantage point to see. And he's telling you that he was unable to identify him. Again, when you have inconsistent testimony, you have questionable testimony, it leads to doubt. And that's what you must infer and reach reasonable doubt in this case. And that is what we have. And that's what I told you at the beginning. That's what I'll tell you now. The state has failed to meet their burden. You may think, again, you can be 50%, even 60, possibly 70% sure we think this happened. But reasonable doubt is all that matters. And I'm going to tell you, I don't think the state has reached their burden. They have not proven this case beyond a reasonable doubt.
I like this closing. This guy's doing a good job.
Emily Dixon, she was on the stand. Again, emotions are high, kind of combative, but her answer was plain and simple. She did not see the shooting herself. And then we come back, we talked about Dr. Rajesh Kannan. He testified homicide by shooting, however, no GSR. And again, we cannot stress to you how important that is. Close range shot. Based on the video, they're saying that they're in close proximity, mere feet away, possibly just a foot or less. You should have seen GSR transferred, and yet you don't see it. And again, why is that important? It's because it does not match up with the state's theory of the case. It leads to reasonable doubt. And ladies and gentlemen, it leads to the only verdict that we think you can legally and justly return, and that is a verdict of not guilty. Once again, thank you very much for your time, your patience, and your consideration throughout this whole process. You've been great jurors, and we appreciate your sacrifice for being here. No, Mr. Garahan's going to speak with y'all. Again, thank you. We'll thank you for your verdict and respect your verdict. Have a good day.
Yeah, Your Honor.
Yes.
Defense counsel.
Counsel.
Ladies and gentlemen, I'll be the last one to talk to y'all today.
And then you will go back to the back and deliberate on this case. And I'm going to briefly go through some PowerPoint because apparently that's what all these lawyers do now. So I felt that I needed to do this. And
He feels like he needs to do a PowerPoint because all the other lawyers do it.
Elements of the crime. Daniel's already gone over this, and y'all have seen this many times, but I just wanted to reiterate these elements. The date is not in question. Bear County, Texas. You heard officer testify to that. Defendant has been named in this case. Intentionally knowingly, that's up to you. But the fact is, I think beyond a reasonable doubt, we met that burden many times over in this case. Causes of death. We have that victim, Avante Boys. We have that already. The fact is that it was done by a shooting, and as defense counsel said, it was done with a firearm. A shooting, and it's a deadly weapon. That's paragraph A. Paragraph B, if you feel that's appropriate, that's fine. Act clearly dangerous to human life. Shooting at somebody that's sitting in a car, that's act clearly dangerous to human life. I'm going to go on to count 2, unlawful possession of a firearm. Again, date, Bear County, Texas. The defendant, that's not in question. Possession of the firearm. Again, that's part of the elements that we have to prove for this count 2. Without a question, he's been possessed of a firearm. Many witnesses already testified to that. Many witnesses, 4 to be exact. After a felony conviction, which defense has already stipulated that he has a felony conviction that's passed. You'll see that felony conviction, the judgment, that it's been over 5 years since he's been off of parole or community supervision or imprisonment. So the fact is, it's already after that 5th anniversary release from confinement or probation. So that's not a question. It's a public place. This is a parking lot. He is not to be possessing a firearm for the rest of his life anywhere other than his own home. In this case, it was in a public place, which is a parking lot of that common area.
This guy's wandering around.
Again, the first part's already established, but knowing an offense had occurred, he knew an offense had occurred. At least at that point, he knew an aggravated assault with a deadly weapon had occurred because he had shot at another individual with that deadly weapon. That is an aggravated assault with a deadly weapon. That's a felony. Intentionally and unknowingly concealed this thing, the firearm, which he did. I mean, you had testimony that he had from 2 different individuals that he handed the gun off to somebody else. You've seen it in the movies. Why do you hand a gun off? You get rid of it. Get rid of the evidence. What are you going to do if something happens? Somebody gets shot. You get rid of the evidence. That's what he was doing. He was tampering with this evidence. So again, count 3 is not in question in this case. So again, I think defense counsel said it, and I said it during board ire. Don't check your common sense in at the doorsteps of this courthouse. It's common sense. Use your reasonableness to get that beyond a reasonable doubt. In this case, the state's confident that this is beyond a reasonable doubt. There's not a question of who killed Avante Boyce. It's not a question. Your common sense tells you that. Your common sense tells you this man over here sitting is the one that pulled that trigger that day. And how do we know that? Let's talk about the evidence in this case. Testimony of witnesses. Not one lay witness, meaning a person that's not law enforcement or the ME's office or CSI. Not 1, not 2, not 3, but 7 different witnesses on this case came in. 1, 2, 3, 4 are related to the defendant. His own family came in. Call her Evie Lewis. His stepdaughter. Person that he considered his stepdaughter came in, testified. Who is Avante Boyce to you? She's, I consider that my husband. We have children together. I was pregnant at that time. I had my second one after he died. But what do you consider the defendant in this case? That's my dad. Known him since I was 7 or 8. And she points the finger at this individual. Within feet of her child in the back seat with her, this man here takes a gun and shoots Avante Boyce while he's sitting in the front of that vehicle trying to get out from this man. And he knows he did it because the fact is he was there in that white jumpsuit. He knows that. The fact is, you know that. His stepdaughter knew it. And that little boy in the back seat with her, Avante Boyce's son, was within feet of his father being killed by that man over there. She testified to that. Now let's go to Unique, or I'm Unique. Biological daughter of the defendant came in and testified. Raise your hand, Dad. That's him right there. Yeah, she was angry. She didn't want to be here. We had to drag her in, but we brought her to you. And yeah, she was not the most hospitable. She was a little hostile at times, right? But one thing that came out was the truth. Saw my dad with a gun coming around. He had that gun. He was mad at me, pushing me when we were arguing with his stepdaughter. That, by all accounts, she doesn't lie. That's fine. But she came in and testified, Dad had a gun. You'll see on that video, and you'll see that still photos of that video, that she's on this side of the car. So yeah, maybe she did not hear what happened, or I'm sorry, see what happened, but she dang well heard it. And as soon as that happened, who came around that car? Vernon Dixon, with a gun in his hand. Go on to Donald Neely, her husband. What did you hear him say? When Vernon Dixon came around that car, he said, look what you made me do. I want you to remember that phrase. Look what you made me do. He said he handed the gun off to him. He was scared. He's the son-in-law of this man over here. The son-in-law, another family member. Go to Pearl Barnes. She was there at that scene. You looked at that video. Pearl saw everything that happened. But who is going to come in and testify against their own child? That's his mom. I understand that. You understand that. She was there. She was watching. She saw him. She took him from the scene. She said, why'd you do this? Remember that. Carl says that. Heard a woman's voice coming from that car as it sped out of the parking lot. Why'd you do this? Plain and simple. That's his mom. Go on to Versa Austin, aka Mr. Juicy. It's homeboy, right? Who's going to testify against their homeboy? Juicy was certainly not going to testify against his homeboy. We all know that. He looked down the whole time, didn't want to make eye contact, was not cooperative. The judge informed him to answer the question several times. Last question I asked him, are you scared? Yeah, he's scared. He has to go back and live over there. He has to walk around those streets. Yeah, he's scared. Go on to Carl Cunningham. Independent witness. Just a maintenance guy. Took that picture of this individual over there in that white tracksuit. Very identifiable, might I add, the white tracksuit. He's testified that that was Keno, knew him as Vernon King, and then that last phrase, he said Vernon King Dixon. Saw him with a gun, saw him shooting that car, saw him come around and hand that gun off, and get in that car and take off with his mama, and heard her say, why did you do this? Belinda Boyce brings in something very interesting, a voicemail, what I call the butt dial in this case. Let's talk about that, the additional evidence, but I'm going to skip to the voicemail. The voicemail. What was said on that voicemail? You can't hear a lot. It's a little mumble jumbled. I mean, if anything, you need to listen to that again. But one thing you will listen and hear on that, something that sort of goes with what Donald Neely said. On that voicemail, you will hear, they made me do it. What did Donald Neely say that the defendant said when he came around that car? Look what you made me do. Listen to that voicemail. It says that. We already heard from Evie that that person is Vernon Dixon saying that. That corroborates between Donald Neely what he testified to, and that voicemail. That's a match. Another match in this particular case is Carl saying that that gun was handed off to who? Donald Neely. Why would he make that up? That leaves credit to Donald Neely of what he said. You look at these pieces of evidence that come in, those puzzle pieces, and they're falling into place. Clear cut. It's beyond a reasonable doubt. It shows that those puzzle pieces make a very clear picture. The security video in this case, without question, hey, I would love to have a video of every murder that I ever tried, or for that matter, any murder that ever happened. That would be great. But this is not a perfect world. This is not a perfect scene. The fact is, we don't have the actual shooting, the smoking gun in his hand. But you got testimony that's credible, that you match it up with another puzzle piece, which is the videos on two different angles. And it's very clear. It's beyond a reasonable doubt.
5 minutes.
Thank you, Your Honor. The white tracksuit, which I really, in this case, seals his fate. So identifiable from across the parking lot. Yes, there might be a tree in Carl Cunningham's photo, but what you can see clearly through that tree and those leaves is a white tracksuit standing there with his arm up. It's clear as day. Talking about GSR in the defendant's vehicle, there's GSR on the headliner and GSR on that seat where Avante Boyce was killed. No GSR was ever found on his hands, meaning that he most likely did not possess a gun or anything. And in this case, there's been no evidence that Avante Boyce did anything except for try to stop a physical altercation between females at the scene and got shot by this man senselessly. Bullets that were found in Avante Boyce came from the same revolver handgun. You heard the doctor in this case testify to that. You heard the lab technician scientist come in and testify to that. Both shots came from the same gun. The defendant fled from the scene with his mom. It's not a question. And then he fled to Kansas. You can use that as guilt against this individual. If you flee a scene after you shot someone, you're guilty of murder. In this case, he's guilty of murder. You're going to see in that video, if you need to watch it again, but you've seen it several times, but there's several different clips. I put still video photos in so you can look at the times on those still videos or photos and be able to match up for the video. But you've seen the video several times. Mom arriving. Defendant in that white tracksuit identified. That white tracksuit again. You see it from across the whole parking lot, that white tracksuit. Again, photo by Carl. White tracksuit. You see the defendant, at moments after the shooting, the defendant's on the other side of that car. I put two yellow circles on this in particular. If you look at this, the circle to your left, all the way to the left. You know who that is? Mr. Juicy. Because what did Mr. Juicy say? One thing that he said over and over and over, if I hear gunshots, I'm running. I'm out. He's all the way across the parking lot. Gunshots have happened. Victim is laying outside that open car door, and the defendant is coming around with that gun in his hand, and everybody else is standing there. And I don't know if you can see this, but I'm looking up there and I see Miss Pearl right there in the middle, leaning up against that picnic table. Because if you watch the video, Pearl walks to that car. She identified herself. She saw the whole incident. Right after, the defendant handing off the gun, circled in yellow there, to Donald Neely. Pearl and the defendant leaving that white tracksuit, get into that car. And if you did catch this video right here, the still shot shows that white tracksuit. And again, there's that white tracksuit following him throughout this case. Him pointing to his mom to take a right. The puzzle pieces equal a clear picture, and it points in one direction. Only one. It's that direction right there. Vernon Dixon shot Avante Boyce for no damn good reason. It's senseless. It was stupid. And yeah, it doesn't make sense. But use your common sense and your reasonableness in this case. The defendant is guilty of murder on count 1, unlawful possession of a firearm on count 2, and tampering with evidence on count 3. Plain and simple. Vernon Dixon is guilty of murder, and hold him accountable, please. Thank you.
All right, ladies and gentlemen, you have heard all the evidence that you're going to hear in this part of the trial. So I'm going to send you back to the jury room. But before I send you back, if I could have Miss English and Miss Priest, please remain. All right, everyone, please rise for the jurors. All right, everyone, please be seated. Defense and state, if you'll come with me this way. I know. I was funny. I was trying to think. It's funny because like you haven't said all the words. You figure it would happen, right? But I guess it does sometimes. All small rooms are going. We're good.
You ruined the parking lot there.
Oh, it tends to happen, right?
Yeah.
Oh.
Oh, we got a crowded courtroom. Yeah.
Okay, so I tried to DoorDash myself some Mountain Dew, and it went to the wrong town. I screwed it up.
No, I can't.
Well,
all right, thank you.
I agree. She sent it to me.
All right, everyone, please settle down. Not too loud. Alexander Castro.
Yeah,
all right.
I just took it all out.
Hey, on civil law, Kurt, how you doing?
Andrew Arnett.
Let me turn down
Andrew
the judge
Arnett.
real quick.
Anthony White.
Let me tell you what's going to happen here. We are, as the jury goes off to deliberate, I think that's what they did. I was trying to see the DoorDash guy, and he's like, "Yeah, am I at the right place? I ran outside in the wrong
Martinez.
town."
Heather Martinez.
Let's go here. I got a box. I was not expecting a box. It's addressed to me, though. I think this might be from 6-Volt. So here's what's gonna happen. We have an interview this afternoon. We have another an interview with the wife and business partner, law partner of Greg Anderson, who was the lead attorney for the Maya Kowalski trial. She's going to be joining us live. Let's see. Okay, interesting. I'm not sure how that happened, but. Anyway, she's going to be joining us live, and possibly two of her paralegals as well, who have all the scoop and all the details of everything that happened. We have additional pictures. We have new audio of Beata that was not played in court, you haven't heard yet. We've got that. We have additional pictures. We've got a song that Maya wrote that we're going to be sharing during that live stream. I'm going to shut down this live stream and it will port you over to the next one, but we don't start for about 50 minutes, 53 minutes. So we get a little bit of a lunch. Yes, I need an assistant so bad. Apparently, the DoorDash guy is mad. I don't know how to get him his tip because he tried to deliver it, and I screwed up the address, apparently. So if somebody can tell me how to do that, I feel bad. Anyway, let's see. I've been watching quietly, waiting for Mrs. Anderson. She's going to be here shortly. It's going to be a new stream. I've got to start it up on StreamYard. Is it National Pickle Day? I have two jars of spicy maple bourbon pickles waiting for me in the kitchen. I didn't know it was National Pickle Day. What's in the box? What's in the box? I'm not sure. It's not growling or ticking, and so far so good. I don't have anything to open it with. I can only guess that this was from someone who wants Mrs. RA to join us on the podcast or join us on the show because I have a new mic. I don't know who sent me this. Was this from 6 Volt? I got it it came from Sweetwater, our sweet way of saying thank you. Six Volt, is this from you? Is this from you? That is awesome. Thank you very much. I think this is for Mrs. RA. That I need to get her on 6 Volt. Thank you very much. This is the exact mic that I use right here, and he got me another one so that I have one for Mrs. RA, which is just cool. That is really, really cool. Thank you, 6 Volt. One of my great mods. All right. So now I have no excuse. I've got to get her on, and get her on camera and everything. Thank you. That is super kind. What kind is it, Judy? This is a pod mic made by Rode pod mic. They're really nice. It's exactly the same mic I'm using right here. It's the same one that the Weather Watch uses on our podcast. It's a great mic. I love them. Okay. Let's see. Use the Rode NT1A myself and love it. I've got one of those as well. It's a very sensitive mic, and where I have lots of kids that run around in the house, it picks up everything. So I can't run a condenser mic like that. I have to use a dynamic. All right. So DoorDash is mad at me. The dude's mad. I don't know. Oh, he's calling back. I don't know. You guys want to hear this call? Hang on. Let's see what happens.
Please note
Hello.
that this call is being recorded for quality and training purposes.
Hello.
This is DoorDash support team. I'm calling regarding your order from Speedway. So
Yeah.
Dash just told me that there was a mistake with the
Yes,
address.
with the address. I've got
Instead
the
of
wrong
Greenville,
city in
yeah.
there.
It's okay, but I'm just requesting from you, can you text the Dasher with the correct address so I can continue to...
Yeah, I can do that. Hang on 1 second. I think he just called me a minute ago, so I can text back to that number. Okay. All right. Thank you very much. Bye. Okay, so yeah, I messed that one up. Let me text the Dasher here. What was my most recent message? Putting my address on. Okay, I just sent it. And now I'm going to... Come on. Okay, I'll try to figure this out. All right, DoorDash is hard to use, guys. I've only done this once before. Once I DoorDashed something and I had it delivered to a guy it was on the street corner up in Washington. I was watching him on a security camera video, and he had sat there forever. And I'm like, as long as I'm watching, I'm going to send him pizza. And I sent him a pizza. And of course, DoorDash calls me as they're trying to make the delivery. And I'm like, we're here. And I'm watching the security camera, the live security camera footage. I'm trying to describe, because the guy doesn't know the pizza's coming, right? so because I don't know who he is. He's just a guy that's hanging out there. And so I'm like, I'm the guy. I'm sitting over there by this truck. You know, I'm looking this way, and I've got a little bit of delay. And finally found it. It was pretty funny. But now I've tried to send something myself, and it didn't work. All right. That being said, we hopefully I get my Mountain Dew. Now I'm gonna owe him a huge, because it's like 10 miles out of his way. How much of a tip do I owe somebody if they have to drive 10 miles out of their way? Yes, I did. I DoorDashed a pizza to somebody who did not know that we were there. $10 tip. Okay, I'll do that. And I guess I give him cash, right? Because that way it's all cool. I was already going to give him $5, but I thought he was just coming from like a block down the road. All right. Anyway, either way, we are going to get going. Please, as soon as this live stream ends, we're going to jump over to the new one, it will jump you over to the new one, so you can click the notify me when I go live button. We're going to be live with Jennifer Anderson and two attorneys, or two Kelly and Katie, two paralegals. And we're going to have some great inside information, lots of cool stuff to share with you. Also answering your questions. And hopefully I get some Mountain Dew before all this happens, so I don't fall asleep mid-interview, because the 3 hours of sleep I got were not enough, as it shows. Rejected juror. I literally, I've never DoorDashed before, other than to that person up in Washington, who I was just watching on a security camera video. All right. That being said, let's wrap things up here, because I've got to get ready for the interview. There we go. Let's see. You can add a tip after delivery too. I'm gonna go scrounge up some cash. I'm gonna go break the piggy bank and see if we've got some cash I can give him. I do feel really bad. Of course, now they're not going to be cold. The Creative Bee. I have not been to the post office yet. This one came right to my house, but. The post office where I normally get stuff, so I will watch for that and let you know. Thank you very much. All right, tonight when you go home, please hug the people you love, smile at someone to make that day just a little bit better, and please stay safe. To go live again in about 45 minutes with Jennifer Anderson, law partner for Greg Anderson, the legal team that represented Maya Kowalski, and Jennifer and Friends is what we're going to call it. But if you stay right where you are right now, we're going to move you right over to that, and it'll be ready. We'll be waiting for you there. Please invite friends and bring your questions. It should be a wonderful time. Thank you, guys. I appreciate it. I've got to get this Mountain Dew issue sorted out and find some money for some cash to tip the guy. But it's going to be good. Thank you all. We'll see you in a little bit. Have a good one. Bye. It's going to be good.
How does he do that?
Is that crap.
I was kicked back, taking it easy.
Scratch all that. All that